Morning, ladies and gentlemen. We can quickly be all seated and make ourselves comfortable as we are about to start. So, I was telling someone that I will be facilitating a media briefing session this morning, and the advice to me was, don't be too witty, don't be too charismatic, and don't be too intellectual. That was an advice that I received from my 7-year daughter. I looked at her and smiled at her innocence, and I'm like, that's not a good advice to walk into in a room full of journals and highly esteemed guests. When I go to work, I rock up in the true form of a RAF in spirit. I need to show up that way, and that is how I'm showing up today. So in the true RAF in spirit, I salute you all, ladies and gentlemen, and welcome you to our briefing session here today. And I would like to first start by apologizing for the late start due to some unforeseen circumstances. We are now all here, and we can go ahead with the proceedings for today. Before we get into the business for the day, I just want to then highlight one quick thing from an occupational health perspective. In case of an emergency, the alarm will go off, but don't be panicked. Our OHS officers will then show us where our nearest evacuation point is. Let's avoid rushing and running in front of each other. That being out of the way, we are going to have this session in a 2-segment format. The first one being that our Chief Executive Officer will come up and announce our RAF audit outcomes for 2023, and then outline the Road Accident Fund Amendment Bill 2023. And then after that, the second segment of it will be wherein we afford you an opportunity to then ask us questions, and I will explain how we're going to go about that when we get to that section. So without further ado, ladies and gentlemen, I'm going to hand you over to the Chief Executive Officer of the Road Accident Fund, Mr. Collins Litsano. Over to you, sir.
Okay. Thank you very much, ladies and gentlemen of the media, South Africans in general, our special guests that are here from Namibia that have joined us this morning. Ours is to come and present our audit outcomes, as we promised South Africans earlier on, to say once the audit has been done, we'll come out and report what the audit outcome has been. And we took the advantage of that in introducing that by also dealing with the issues that are quite topical, which is the amendments of the RAF Act. As you would know, those are driven by the Department of Transport, but I think it's important that we answer to some of the misinformation that is out there, and it becomes important that South Africans know what we are doing. We will deal with that as we move on. But I think What is important for us is we are presenting financials that are going to indicate, also from an audit perspective, even cleared by the AG, that the road accident fund has performed 91.3% to achieve on its targets for the year 2022-2025. When the board was appointed in 2019 and was tasked with turning around the organization, the RAF was confronted with a myriad of challenges at the time, key amongst which was the risk to financial and operational sustainability. It is important to indicate that these were not contemporary challenges which started in 2019, but in fact dated back to the fund's establishment in 1946 as a compulsory insurance scheme under the Motor Vehicle Assurance Act 29 of 1942. You would see that, notwithstanding the fact that in 1942 this act was passed, it took 4 years for the then government to put this together. And of course, the fund legislative framework has undergone 6 amendments over the years, with no less than 7 commissions of inquiry being established to inquire into structural defects of the funding and operational models. So what would happen is that the RAF would collapse, or the scheme would collapse every 10 years, so to speak. So it has never been sustainable since its formation. Following the 1998 white paper, the Southwell Commission was subsequently established in order to avert what was clearly considered a crisis at the time. And as defined by the problem statement in the Commission, that the system at the time was financially unsustainable and measures needed to be taken to achieve a system that would be affordable and stable in the long term and yet be able to offer a reasonable set of benefits. The system needed to be more efficient and thus reducing the high cost at the time in terms of the time, effort, expertise that needs to be incurred in the process of delivering benefits. We are the only organization that you need to prosecute a claim with, which is a social benefit organization, which is a problem because then much more of the claims process is much more litigious. The system has to be more effective, thus avoiding shortcomings and anomalies and inequities. As inequality is one of the issues that we are dealing with in this new model. The RAF's 2020-2025 strategic plan was therefore developed to effect a turnaround and to finally put the fund on a sustainable financial and operational path. The following were some of the challenges that the RAF's 2025 strategic plan intended to address. The first one was the long turnaround time for settlement of claims. It used to take just over 5 years to settle a RAF claim, and one would know that it takes about 3 years for you to be able to do that. So if you do it at the end of the 3 years, it took us another 5 years, which will increase the time from the accident to be about 8 years. And as clearly illustrated in the table that we will show, the RAF in 2015-2017 decided on a plan. In their strategy of 2015-2017, they wanted to settle claims in 1,400 days. That notwithstanding the legislative requirement to do so in 120 days. This consequently resulted in the claims backlog, which snowballed to over 300,000 claims in 2019. It is against this background that the RAF 2020-2025 strategic plan identified as one of the outcomes the settlement of claims within 120 days. The Auditor General, in our audit report, commends the RAF for not only achieving its strategic focus to settle claims in 120 days, but also achieving this target for the first time. Although the RAF is still a long way to settlement of all claims within 120 days, the overall turnaround time has shown good signs of improvement. The biggest impediment to this target remains that 90% of claims that RAF backlog were lodged without required minimum information to enable the fund to make a settlement offer. The introduction of RAF Form 1 will go a long way in addressing this challenge. To this end, the AGSA notes in the management report the following, and I quote, "Management has reported an achievement of 88.95% of claims validated and verified days against a target of 55%. The major contribution of this was through the introduction of RAF Form 1 on a mandatory requirement for valid claim. This ensured more credible data being maintained on valid claims and can be processed within 120 days, and also ultimate ability in respect of the claims registered on the RAF system." The second one was the RAF claims liability. In 2020, the requested but not yet paid book was about 17 billion, and it was expected to increase to 51 billion as at the end of this financial year that we are reporting on the 31st of March 2023. If the RAF had continued on this highly litigious and ineffective model, they would have exceeded the annual RAF fuel levy income. So RAF was supposed to collapse in this financial year because the levy income would have ended up at 48.4 billion versus the 51 billion of our RNYP. Simply put, it would have meant that it would have wiped out all the revenue that we had. Through the implementation of the 2020-2025, the projected increase to 51 billion was not only averted, but what happened is that we actually reduced this RNYP to 9.3 billion. It was supposed to be 51 billion. We have reduced it by more than 40 to around 42 billion. So that must tell you what we have done. This was an extraordinary achievement against the backdrop of the COVID-19 impact and not receiving any fuel levy adjustment over the last 2 years. It is important to know that RAF never received any bailout during this period. Neither did it request any bailout. So that must be seen in that context. No increase, no bailout, a reduction of about 40 billion. That is the story of our liability. The AGSA sums this up in our report as follows. This reflects that the majority of the net fuel levy is directed towards payment of claimants' compensation, with a steady reduction in the claims but not yet paid book. And the third one is the RAF litigious model that had to deal with what we call the legal costs. The RAF litigious operating model that was in the past. When describing the RAF litigation strategy implemented between 1997 and 2019, Judge Bertelsmann found in Ketsekele versus the Road Accident Fund in May that the fund's approach to litigation constitutes a serious dereliction of its duties to road accident victims, the public and the courts. He further found that the fund's legal representatives were as complicit in operating a scam as were those of the plaintiff. As clearly illustrated, the strategy has traversed effects on the RAF legal strategy and 19. If you projected it out, you were gonna likely get to a point where the projected cost would have grown to over 50 billion by 27-28. You will see Judge Bertelsmann, who wanted that radical change and to provide a solution to the what he called to provide a solution to the present morass of the need, paint a worrisome proposal that the new agency will approve the existing fund structures, which is why we have changed the way we operate the RAF, and which is why we have now a new structure. He argued that with such assimilation, the agency, he says the agency will be exposed to the risk of perpetuating the fund's culture of indifference to human suffering and financial waste. And he says if so, the agency will be settled with the inheritors damnosa a cash inheritance that will doom it to fail virtually immediately. So the 2025 strategic plan was therefore premised on effecting a radical change, presenting a complete departure from the litigious and financially wasteful model Judge Bertelsmann warned about. Of course, as part of the achievement, the AGSA confirms the following. In the management report that we received, that the drive to reduce legal costs has yielded positive results in that 60% reduction was reported against a target of 30% against the set baseline in the annual performance report. So we doubled our performance here. The actual legal cost paid were 3.7 billion against the baseline of 9.4 billion and the planned target of 7 billion, which will ensure that available funds are directed towards payment of claimants' compensation. In the recognition of the work done to reduce medical costs and improvement of medical management, the AGSA knows the following. The RAF has achieved its targets for medical tariffs that were developed in 2022 as they have now been implemented. This indicator relates to the fund's efforts to reduce medical costs for serious injuries that are associated with or part of the settlement of claims in delivering on its mandate. This indicator presents entities' response to reducing medical costs by prioritizing regulations to improve serious injury assessment and also implement medical tariffs as well as the pre-authorization model. Furthermore, the AGSA acknowledges the improvement in the control to prevent the duplicate payment. The management report reports that in 2020-21 financial year, certain duplicate payments were identified caused by the bank attachment process. Since December 2020, through implementation of certain controls, no further bank attachments have occurred and no duplicate payments. Management has instituted measures to recover these duplicate payments, supported by the investigation of the Special Investigation Unit, the SIU. This ensures that available funds are being used to pay claimants' compensation and thus avoid further financial losses. We then move to the performance. 2020-2023 predetermined objectives. An illustration of the dashboard will show you that there has been a steady improvement from 57% to 91.3% in this financial year. Importantly, the AGSA confirms in the audit report the following. I did not identify any material findings on the reported performance information of outcome 1, which is a transformed and sustainable RAF. I must emphasize that in 2019-20 we were sitting at 57% performance, 2021 78%, 21-22 84%, 22 the RAF is in a crisis, to show us the measure they have used. The matrix says that we have is very clear. We then go to the audit results per outcome area. The overall audit outcome of the road accident fund has improved compared to the prior years, as an adverse audit opinion was expressed compared to a disclaimer opinion received in the previous year. The RAF engaged meaningfully with the AGSA throughout this audit process, and the audit report issued in 22-23 is modified only as a result of the ongoing disagreement between the RAF and AGSA regarding the accounting treatment of claims, liability, and expenditure. When it comes to the outcome area of financial statements, the movement is upward, which is an improvement. a transformed and sustainable RAF annual performance report that also has improved. Financial statements and performance and report and annual reports remains the same. We know why the issue is like that. It's because of the disagreement we have. Procedure and contract management, positive outcome, upward improvement. Expenditure management, upward improvement. Asset management, same level where it is unqualified and there's no material findings. Consequent management, it's an upward trajectory. And the strategic plan and performance management remains the same and unqualified with no material findings. So if you look at that, you will see that there is only one area that it has not shown an improvement, or where there was effectively a possibility of an improvement and there was no improvement, and it's financial statements as it were. So this is very clear from where we are sitting. Then of course there is our statement of financial position, where you would see that our net liabilities position has increased. And we must emphasize this, why it has increased. It is driven more by the fact that we have been driving down our backlog. In driving down the backlog, can we maybe just switch off the sound? Thank you. Let's just switch off the sound here, please. Okay. The statement of financial position effectively shows a liability growth of from 15.3 billion to 23.8 billion. This is mostly as a result of us trying to drive down the backlog. So the more offers you make against what you have, the more liability is going to show, because once you put that as offers, they then become part of what we call our liabilities as we move forward. So we balance that. So the RAF recorded a deficit of 8.43 billion versus a surplus of 428 million. This was largely due to the fact that we have not received an increase in the fuel levy over the past 2 years, whereas inflation was shot up on an average of 6.9% during 22-23 financial year. The deficit has also impacted on the increase in the claims liability as compared to the previous year. The increase in the claims liability during 2022-23 was mainly driven by the net increase of 32%, for which offers were made and not yet requested, compared to 21-22 financial year. Our drive to reduce the backlog to settle claims within 120 days would have the resulting impact of increasing claims offered but not yet accepted. Therefore, an increase in the claims expenditure. We'll give you the statistics there. So finally, in conclusion, there is no doubt that the RAF is not out of the woods yet. We don't want to claim that we're out of the woods, as it were, which is why there is a need for a holistic change to a lot of things. The fund still faces significant challenges. However, what is undisputable is that the 2020-2025 strategy presents the best opportunity to finally see the RAF on a sustainable financial and operational path. The focus should therefore be on optimizing what works and managing the inherent risks that comes with implementing the turnaround plan. I think for us it becomes very important that we put paid and settle to the fact that people were saying the RAF is in a crisis. An organization in a crisis that performs 91.3%, I would want to be in a crisis every time. I would love to be in a crisis if there is. Compares to the entities that got bailouts, compares to our predecessors, compares and be fair in the comparison. And that for us becomes important that we put pay to this. The annual report will come in due course, but those are the audit outcomes. I think let me then move to the issues around the amendment. Can we still switch off this? Is it from here? Okay, thank you. The amendments to the RAF Act are very important, and I think people are distorting this for obvious reasons. But I want South Africans to apply their minds. There is a known, what do they call it? They always say you must join the dots. You must join the dots. It's very important that people do that. There is a reason for this misinformation that you are seeing out there. But I want to ask South Africans, and I want to read a certain provision in the RAF Act that becomes important. That is going to tell you why you are going to be told, no, you know, our people are done in, they will be paid less benefits and all those things. But you are going to see a very strange phenomenon. It's going to come from lawyers. It's never going to come from the claimants. It's going to come from lawyers, and they are going to call themselves civil society. So they're going to form organizations that are going to try and fight this. Last time when there was a thing called RAPS, Road Accident Benefit Scheme, we saw the emergence of an organization called Association for Protection of Road Accident Victims. And it was just lawyers. Right? And there is one that has just been formed, it's called PIPLA. No, Personal Injury Something, Lawyers Association. Right? So you are going to see that. You will see the emergence of this. But here is the fact. Okay? This is the reason. You must go to section 19C of the Road Accident Fund Act, and it will tell you why. 19C says, 19 says liability excluded in certain cases. The fund or an agent shall not be obliged to compensate any person in terms of section 17 for any loss or damage. Right? And C says, if the claim consent has not been instituted and prosecuted by a third party, which is the person that is injured, or on behalf of the third party by, listen to this, any person entitled to practice as an attorney within the Republic. We know who that is, right? These ones who are making noise about all that, I suspect they come from this provision. But then I want to read you the second part. And if you are able as a South African to know who this person is, a lot of money behind this, so that you will is in the service, or who is a representative of the state, or government or provincial, territorial, or local authority. Who is this? It doesn't say RAF employee. So it tells you, in this particular act, people had written themselves into the legislation and they had cornered this, simply meaning, if you come here and if I help my own mother to lodge a claim, that will be unlawful and the RAF will not pay, because I don't belong to that.
That's what it means. So we have to change this. We have to change a situation where there is a social benefit scheme that needs lawyers for you to come to. That needs an actuary up front before you arrive at our door. And this is the reality. And of course, they will tell you, it is very cumbersome to go through a RAF system. We advise you to seek the assistance of a lawyer. When we try to change this, they say, do not change it. Now, there is a view, and I think I've just taken certain aspects that are important, that are being distorted out there. So there is a part what says RAF is an insurance. I'm sorry to blow the bubble of those that claim to be in the know. The RAF has never been an insurance. In fact, I'm going to quote for you that RAF has been a social security fund since at least 1999. So this amendment just seeks to clarify. I don't want to, we are not changing. People are saying we are changing it from a compensation system into a social benefit fund. It has always been a social benefit fund. So if you look at Directive 1, if you actually, let me start the other way around. If you look at the institutional sector classification guide published by the South African Reserve Bank in December 1999, and you go to section 8.4 and you see the classification of the road accident fund, you are going to fund it under social security fund. That's a fact. Okay. The fallacy is that RAF is a compensation scheme. That is not a social benefit fund. The fact is in the Reserve Bank Institutional Sector Classification Guide of December 1999. You're welcome to go and just top study. It will show you. Now, recently, as recent as 2011, I think it's clarifying what RAF is. The Financial Services Board on the 15th of February 2011 issued a Directive 1 in terms of the Financial Supervision of Road Accident Fund Act, number 8 of 1993. And in section 2.3.3 of that directive, it says the following: in assessing the viability and sustainability of RAF and its compliance with provision of the Short-Term Insurance Act, identified under paragraph 2.2. Listen to this. Consideration will be given to the status and nature of the RAF as a public entity that is fundamentally a social security fund. So, our learned friends must just go and read. In assessing RAF's compliance with the prudential requirements of the Short-Term Insurance Act, consider that. They don't say an opinion, they say the effect. The RAF's model is not based on insurance principles, as the premiums payable, in this case the fuel levy, does not directly correlate to the benefits provided. Amen. So we can't go past that. So let's then deal with this issue of, the defined benefits are going to take away from what we have. There is no truth to that. Because what are these general damages? You must tell someone to say, can we just do an equation on the general damages? I need an actuary. Best people to tell us how to calculate general damages must be an actuary. They also don't know. Because they don't know what these general damages are. Because you have been paid your loss of earnings, your medical costs are covered. What is this general damages? No one can tell you. No one can tell you. We believe very strongly that the rationale for defining the benefits is to simplify the benefit structure of the RAF. It's very important to do that. So that you know how much you are going to get. You can make, if you are like me and you can afford another cover, right? And the people that are sitting here, I suppose they are able to get another cover. They don't need a social benefit fund. And this is the inequality of the RAF system. The poor in this country get the lowest. In fact, your child who gets injured, like my helper today, if my child gets injured, they both get injured at the same time with the same injuries. My child is going to get more. Simply because the father is a CEO. It's calculated on the basis of, okay, let's get the probability of this child graduating. If I got injured some time back, my mother was not a CEO. She also does not have a degree. So it means people would have projected my injury to be different, and I would have been paid less than a child whose father was a CEO at the time. And I think that's what we're trying to clarify. And we are saying this must be equitable. This is the most regressive type of taxation, by the way, or benefit scheme that benefits the rich. If you earn more money, you get injured, you get more money from RAF. If you get less money, you get less money from RAF. But you are covered the same because R2.18 is the same either. So we are trying to simplify this benefit structure and of course get rid of the thumb sucking exercise of a thing called general damages, which cannot be explained by anyone what it means. Now, people are going to say, no, they have now stopped paying medical aids and they want to say, let's not pay medical aid. That's also clarity. By the way, there is no story. You can go to the RAF DADs, read it through, and you must see where it means medical schemes. Nowhere. So the underhanded way in which medical aid claims from us is forcing their members to claim. They demand that you as a member, you must go and claim, and once you have claimed, give the money to us. If you don't, we terminate your membership. Yes, that's a fact. You can go and look at it. It's a ruling. This is also endorsed by the Council for Medical Schemes. It's a ruling by the CMS. It's called, I think it's a Bellon judgment. R. Boborov and partner, you know who Boborov is, on behalf of Mr. M. Bellon versus and Discovery Health Medical Scheme, a registrar's ruling that allowed the medical scheme to reject a person and throw them out because they refused to pay the money they received from RAF to the medical scheme. Now, strange. I am a member of the medical scheme. I don't want to be running after RAF after they did what they must do in terms of section 21O and P of the Medical Schemes Act. It says, 29 says matters for which the rule shall apply. So the prescribed minimum benefits and emergency medical conditions as defined by the Medical Schemes Act have been excluded. Specifically, we're clarifying that is a position anyway. The registrar shall not register the medical scheme under section 24, and no medical scheme shall carry on any business unless provision is made in its rules for the following matters. O, the scope and level of minimum benefits that are to be available to members and dependents as may be prescribed. P, no limitations are applied to the reimbursement of any relevant health service obtained by members from the public hospital where this service complies with the general scope and level of contemplated in paragraph O and may not be different from the entitlement in terms of the service available to a public hospital patient. Then let's go to the MSA regulations. Regulation 7 defines the emergency medical conditions and the prescribed minimum conditions, minimum benefits. The definition of emergency medical condition is the following. It means a threat, the sudden and at the time unexpected onset of a medical condition that requires immediate medical or surgical treatment, where failure to provide medical or surgical treatment will result in serious impairment to bodily function or serious dysfunction of a bodily organ or part, or would place the person's health in serious jeopardy. That's the immediate medical condition. So I suspect that if you get injured seriously in a vehicle accident, this will be part of it. The second says the prescribed minimum condition means benefits contemplated in 2910 of the Act and consists of the provision of the diagnosis, treatment, and care of A, diagnosis and treatment pairs listed in Annexure A, subject to the limitations specified in Annexure A, any emergency medical condition, prescribed minimum benefit condition, means a condition contemplated in the diagnosis and treatment pairs listed in Annexure A, or any emergency medical condition. Then, Regulation 8 says the following. Subject to the provisions of this regulation, any benefit option that is offered by medical schemes must is peremptory, pay in full without co-payments or use of deductibles the diagnosis, treatment, and care cost of the prescribed minimum benefit conditions. Now, we now put paid to the fact that there was no any provision in law that allowed medical aids to come and claim this money. They must show you. They must show you. And they can't go and abuse their members and tell them that, no, this thing is going to increase your medical aid subscriptions. Because this has been accounted for. In fact, Discovery in 2014 told people that they treat accident victims, road accident victims, or the injuries and the claim like any other injury. That's what they said. What has changed, we don't know. But the reality is this: South Africans must be disabused from this concept of RAF being recalcitrant, saying things. Everything we say is backed by the law. Let them show you what is in the law that says that. And of course, the funds liability to collisions on public roads only. Then they say, no, but if I'm in my driveway, my child drives and hits me without a license, the RAF must pay. That's what is happening currently. And then, of course, the National Road Traffic Act says you are licensed to operate a car on a public road. When we say let's align the two acts so that you are not, while you are in your driveway, please insure yourself. You can't expect us to do that because there is no enforcement there. When these private spaces where you injure yourself, this is where all this fraudulent claims come from. Because it's in a private space. We don't know what happened there in that driveway. It is the story that we must. When you on a public road, police will be involved. We know investigators will be involved, and things have become easier. And it's just that alignment that we need. We need to specify public road for obvious reasons. And those that want to fight this they must tell us what is it that they want to see. They say farm roads and all those things. And we are saying, well, most of these roads are declared. So if you've got your own private road there, why should we be covering a space that if we find you driving without a license, we can't tell you, just say, this is my space. It's not on a public road. Now, payment in annuity. Simple. Okay? So South Africans know I blew it. No one does not know I blew it yet. There are people of the Lotto, there are people of RAF. Majority are RAF. Right? It's simple. We are just aligning this to global best practices. We have never seen any social benefit fund anywhere in the world that pays in lump sum. Show us. That's all we are saying. I have just been dealing with a thing, and a colleague of mine told me about a child who received money from RAF, about 2 million rands. And the mother blew the money. The child wants to go to school now, the mother says the money is not there. If we paid in installment, we will start the time this child is prepared, 16 years, we pay in installments. It makes sense. But your loss of earnings was never going to be in a lump sum. If you lose earnings, your earnings, the trajectory of earnings was always going to be monthly in any event. So we are replacing what you are losing. So how do you replace what you are losing? By giving you upfront what you are supposed to get. And I posture this. If people want to go and investigate this, they must investigate it. 80% of the people that came through our door and told us they will never work, they are now there in the South African Revenue Services, and they are paying pay as you earn. So we don't know, how do you pay as you earn what you have not earned? So here's the issue. When people know they are going to be paid in lump sum, they just claim they'll never work. They wait for the day RAF pays because it's in full and final settlement, and they go back to work. After receiving some 10 million, they then simply go back to work and work again. What are you going to do? Nothing. It was in full and final settlement. That they lied to us, they exaggerated their injuries and all that. So it actually is giving them an incentive to exaggerate their injuries if they are paid. So we want to intervene. We want to come and say, why are you now paying pay as you earn when you said you'll never earn? And they must explain that part. Then of course we will know, then we stop. That will encourage people to actually go back to work. Exclusion of foreigners. Hoo-ha about it. We love foreigners. We have our colleagues here from Namibia. No problem. No problem. But you go to developing countries. I've traveled the world. When I need a visa, they tell me insure yourself first. When we see your insurance, want to see if it's your medical insurance, we also want to see if you die in this country, how are you going to be repatriated back to South Africa? These are developed countries. Why does South Africa think it can afford to get people from developed countries coming here and we cover them? It is not something South Africa, it's not sustainable. But it is not a global practice. We are aligning. People always say, hey, South Africa, they compare us. Your GDP is low compared to. But when we start to say, the same. It covers you. Social benefit must be the same in other countries. You don't just arrive there and get social benefits. South Africa can't afford this. And RAF can't afford it. And for it to be sustainable, we must make sure that there's a model that works. There's nothing about the hatred of foreigner. What? There's no nothing. We are just aligning to global best practice, and that's what we do. So, these are the topical ones that people are raising. They won't raise the part that says we have removed section 19C, where it's only the lawyer that can claim. They won't tell you that because they don't want you to look at that. So those are the things that we are changing. And we are making sure that when we take care of our people that get injured and they've got serious injuries, we do reassess them, we check up front, we do all those things, we authorize, and they say, no, you'll never get a benefit. It's not true. We are now engaging the emergency medical services. We are now pulling part of the act, which is RAF 3, what says you must report an accident. Once people are in hospital, before the 3, we want to know when someone gets injured and when we take a liability. It's very important that we do that, because in 3 years a lot could have happened. So we want that, and then we get involved. We are getting a lot of hospitals to come as well as part of a network. We've got a network of doctors and all that. We are working towards making sure that RAF is accessible for our people. And people say, no, it's because we hate this one and the other. There's no truth to that. Is it personal? It may well be. It may well be. Some of us have got relatives who have never got a cent from RAF when they were entitled. And we know that. And that's a fact. So maybe to that extent that we are saying no other family must experience what we have experienced. That's as personal as that. We want people to get an experience at RAF. And they can't get this experience when the only way they access RAF is go through a lawyer's office, who also lies and says, well, RAF has not responded, even when RAF has responded. So we need to do that. We need to remove the intermediaries in this social benefit fund that has been social benefit since its inception. This story that we are in insurer, that we are compensation fund and all that is not naturally true. So we are a social security fund and will remain like that, and we want to continue like that. So all the things that we are doing, most of them in the new bill, as I said, is something that is driven by the department, but we are involved as well. But it's something that we are saying it's changes, and that's why we are supporting this bill to go through. Thank you so much.
Thank you, CEO, for that detailed unpacking of the bill, as well as letting South Africans know in terms of the progress of the RAF in line with the performance of the organization. I'm sure that was quite a mouthful. This naturally moves us into the next segment of our conversation, which will be to afford you as the media an opportunity to engage on the content that was presented to you by asking questions. So how are we going to do this? I'm going to afford you an opportunity to raise your hand, note, and then before we take the first round of questions, I will want to also highlight that when you raise your hand, please just tell us who you are and which media house you are from, and we'll also afford an opportunity for those who are joining us virtually to ask questions on our socials, and we'll take those as well. So I am there. If my colleagues can assist with the roving mic to take the first question, and then we'll take it from there. Thank you.
Thank you very much. Good morning. My name is Diabo Seton from SABC News TV. Mr. Luswalo, just 3 questions from you. Can you just give us an amount or just an overview of how much in claims and fraudulent claims the RAF has paid over this 2023 reporting period? Secondly, the Parliamentary Oversight Committee, when it came here in its monitoring group and summary, it had very scathing comments to say about what it found here, including what it says is the staff that are unhappy, low morale, and your Midland office, I understand, in its report, that is not doing well, as well as if you could just confirm if you are retrenching any staff members at the Road Accident Fund. Thank you.
Any other takers?
Hello, it's Roy Cocaine from MoneyWeb. 2 questions. Can you comment on your success or otherwise of recovering money from duplicate payments? And secondly, if you actually said everything you say is backed by the law, and yet you have got a case which was brought by Discovery, which you lost. You filed leave to appeal. It was rejected by the High Court. It went to the Supreme Court of Appeal, where it was rejected again because the prospects weren't good, and you have now approached the Constitutional Court. How can you say that everything is backed by the law when you actually had this adverse judgment? And if you could give an update on what the status is of the Constitutional Court application that you've made. Thank you.
Thank you, colleagues. We'll pause at that and we'll take another round. I will afford our CEO an opportunity to tackle those first sets of questions. Over to you, sir.
Yeah. I prefer to deal with facts. Emotions, feelings are always there. And if you come and you say, employees are not happy, we've got 3,200 employees. Which ones are you? You must tell us.
They said there was a survey done.
Yeah. There was a survey done. The survey gives us more than 73%. And the people that did the survey says we have never seen such a thing. RAF as an employer. We have never seen such a thing. There is no scoper that did any survey. So they must tell you where they're getting that from. Our survey, which we give them, says RAF as an employer, thumbs up. Our own employees, independent survey. So, objective facts, objective measures. So someone says, oh, this RAF is a car wreck. I say, 91.3% crisis. Huh? So, confirmed by the AG, not me. Not as if the AG is our friend. They're not. But they've confirmed that RAF has performed at 91.3%. They go on to say, in the achievements, this is what it has resulted to in the hands of South Africans. So when we started, 27 billion went to claimants, only 27. We have paid more than 40 billion to claimants. You are asking about fraudulent payments. I would not know unless I was the fraudster myself. I mean, how do I know how much of the 40 billion was in fraudulent claims? They are just claims. The ones we rejected because of fraud, I would have to go to look at the repudiation numbers. But here is one thing that I want to address as well. You know, it's so easy to defraud the road accident fund, and you just get a slip on your wrist. We had an Eastern Cape person being convicted. I think that person was fined 50,000, and that person must pay it in installments. When they tried to claim some more than 3 million from RAF, look at it. Assess where people try to defraud anyone and where they try to defraud the RAF. I think it's fashionable. People are making it easy to try and defraud the road accident fund, because when they are eventually found guilty, some doctor was made to go and save community service.
So are you conceding that the controls are weak?
No, there's no control over that is weak. I'm saying we have picked up a lot of people that are wrong, and when they are convicted, nothing happens. I'm not conceding to any weakness in controls, which is why we are putting RAF Form 1 that says, give us all this information. Do you know why people want to claim in 3 years when they've been injured? Because they simply know that by that time the doctor would have disappeared. The treating doctor would not be there. The information would have disappeared, which is why we want to collect the money, the information from the beginning. So there are no weakness in controls at RAF. The AG says the following. Says there has not been duplicate payments since 2020. When we arrived here, there were duplicate payments. So I can't understand this weakness in control environment, where the AG says that through implementation of certain control, no further bank attachment have occurred, thus no duplicate payments. It's the AG. They are the ones that test our controls. They use audit procedures. If you walk around here, you may not see these controls, because they are not things you can see. So you can't come and walk around in our building and tell us that no, they are weak controls. The AG sits, performs an audit procedure according to the audit standards, international standards of audit. So that's a fact. And staff have got a low staff morale. I don't know this stuff that has got a low staff morale, but we are changing RAF. So for those that don't like the change, the morale might be low. And that might account for the 29% or 27% if you take 73. But we are not moving backwards. There are people that still want a relationship between them and the lawyers. For what we don't know. We are now separating back office work and front end for obvious reasons. If you go to any insurer or any people where claims are made, it's very unlikely that you are going to meet the person who is actually assessing the claim. Why do they want this relationship? Bring them back. We'll tell you the story. Retrenching of staff members. No, we're not retrenching anyone. And then of course they say, no, people are going to be taken to far-flung areas. That's where our people live. Where do you want them to be? When we say, we are now changing the model, we want you to be in spaces where our people are. They say no. They say no, if you don't go there, they'll retrench you. But that's where our people are. So the people of Mutuba must not be serviced because a RAF employee is refusing to go there. No. We are clear about that. We're a people's organization. We are centered around helping and assisting people. The impoverished are out there. We are going to go there. And any RAF employee that does not want to go there, they are free to leave. That's why we give them a VSP, it's a voluntary. It's called a voluntary severance package. Voluntarily. So if you think this is not the ship you want to be in, we encourage you to leave. There's nothing wrong with that. Right? If your morale becomes low because we encourage you to leave, then there is. But that our people must not be serviced because people don't want to go there because the RAF model is now saying they must go and go. I think we are not going to agree. So there's no retrenchment that will happen. In fact, I think we are going to increase slightly. At the RAF, we are not overemployed, so we don't have issues like that. At the RAF, we suffer the consequence of not servicing our people. The consequence of us servicing our people through a conduit, which is not a very favorable conduit for us. So the only way we service our people is mostly through lawyers, 90% of the time, and therefore how the lawyers feel becomes what the claimants feel. We are claimant-centric. This is the year of the claimant, and we are dealing with this. We have recovered 682 million in duplicate payments so far, or at least in this financial year that just passed. It's a very strange phenomenon, isn't it? That the road accident fund must not have rights. So, when we say this is based on the law, they say you lost. Where? Well, in the North County. What was the case about? Someone is trying to set aside an internal directive. We can write another one. We set it aside, we'll write another one. There's nothing that turns on it. So people make it as if this thing is about the reimbursement right. It's not about the reimbursement right. The part that says no, set aside that directive does not say you have reimbursement rights. That's not what it says. It says set aside the directive. I think we must go and read the ruling. I think we must go and read it. Now, it's very interesting that those that ask us which basis in law are not asking discover which basis in law makes you claim from RAF. No way. They'll never ask them. Because when it's us, we must be asked with code. Yeah, it's them. No one asks them. No one is asking discovery. Why they said what they said in 2014. I think there was a from them. Then CEO of Discovery, who says we never received any cent from the road accident fund, and we have paid out this much for people that were injured in road accidents, who are Discovery members. No one is asking them. What changed? Then they turn around and they go to the court, they then say the fraternity is losing 500 million a year. Of what? Why the underhandedness? If you know you've got a claim, come through the door and claim from us. And show us which provision of the Act. You are not a service provider. So you do not provide services to people. You are not the claimant themselves. Let's go and read section 17 of our Act and be clear about it. There's nowhere where medical aids are included. So they can't claim from us. And they lie there. They say, no, we used to claim from, they never claimed from us. What did they in fact do? They took their members and they said to the member, we have got a law firm here, use them to claim from RAF. Once you are paid, give them and cooperate with these people. If you don't, we remove you as a member. And you claim from the medical aid pays for you. They then go and force you to claim. And when they were challenged in 2014, it's in our statement of yesterday. When they were challenged in 2014, they said, no, there's no such a thing. We treat people, the injury of accidents on the road, and there's the same. We quoted it there. Right. So, we have gone to the Constitutional Court to defend our rights. We will do that. And it's an interesting phenomenon why people then jump to the bandwagon when the matter is less pendent. When the matter is less pendent, they know very well the matter is in court. They want us to get involved in it. We are not going to get involved in the matter of the courts. We believe in our justice system. We believe in our justice system. We are here for those ones that can't speak for themselves, that they are spoken about. So you are going to hear this thing about the draft bill. You just see lawyers coming in form of social society, and of course the lawyer-sponsored civil society will come through. But you are going to fail to find that old woman in Tuba, whose husband has passed 8 years ago, and the lawyer has chowed the money. And then LPC did nothing about it. Yeah, you are not going to find those. Those ones are the ones that are not spoken about. And they are the most important people. They are the most important people. Discovery is not our claimant. They are not. They will never be. And they have got a very nice building, by the way. I'm sure they live nicely. They are cozy where they live. The people that we are interested about is the young girl whose father has passed on. We want to make sure this girl gets the assistance of loss of support as quickly as we can, which is why we are fascinated by the 120 days. Right? So, people will not talk about the insurance industry, by the way. They are the next ones to complain. Maybe I must say this before. The business media goes and says, no, but I must say this about it. So, in 2020, we found out something. There are people that are taking premiums, insurance premiums, for a thing called public passenger liability insurance. They collect that money. So if you want to be in a, you want to have a operating license for a bus, you need public passenger liability insurance because they are public passengers. For taxis, public passenger liability insurance. They've been taking that money. At least since the immemorial. In 2008, when we started covering everyone, they still continue to do that. So for the past 15 years, they've been collecting this money. They've never paid a cent to the public passengers that they've covered. Never. Not a cent. And they rely on the ignorance. We have reported this to the Financial Service Conduct Authority. They came and confirmed that there are 22 insurance companies that do we are still to get their names, because apparently these names can't be disclosed for whatever reason. But you can see, when private sector is involved, they go collect money. They're supposed to pay our people and they don't. And no one cares about that. Right? The majority of public passengers are blacks in general and African in particular. That's a fact. So, and it's worse. The ones that use public transport, majority are Africans that are in townships and everywhere else. They just tell them go to RAF. They don't tell them, by the way, you're a public passenger and therefore we have covered you. So those are the things that we are unearthing as we go along in trying to make this system accessible for our people, and we want those changes. And it's important that those things are set up front so that we understand. So the Constitutional Court matter is in the Constitutional Court. We'll deal with it when we get there. But we must know what it's about. Because people are now disputing what the matter was. It was about an internal directive that was written that was being challenged by Discovery. An internal directive. Go and read what it's about. So people think that is about the application of the MSA, the RAF Act. There's no such a thing. There's no such a thing. So, and by the way, I don't know, Roy, if you looked at the ruling of Judge Kumar. Interesting phenomenon. You guys don't talk about, when it's about it, you say, hey, a twist. When we win, it's a twist. When Discovery wins, hey, it's a twist. You're right, hey, it's a twist. Why is it a twist? Because Judge Kumalo put it clearly that no. Regulation 8 is very clear about the payment of prescribed minimum benefits and emergency medical conditions. He actually in that judgment quoted Regulation 8. But of course, Roy, we are going to forget about that part of the Kumalo judgment, because the Kumalo judgment does not forget the narrative. It doesn't. Discovery went and applied for an 18-3. They failed dismally, and they want to downplay it. But there are interesting findings in there. There are interesting findings in there. And I think South Africans must be given this Kumalo judgment, they must read it themselves. And then join the dots and understand what's happening. And by the way, that is the last judgment. In it, Judge Kumalo says, I've taken judicial notice of what has happened in the SCA. At that point, the SCA had already rejected this thing, and that RAF had applied to the Constitutional Court. He says it. I think it's in paragraph 3 where he says, I've taken judicial notice of the fact that this thing has gone. So he applied his mind to what the SCA is saying before he arrives at his conclusion to say, I don't see this thing. There is no merit in your argument. That was the last case we had in front of the judiciary. We won it. No one is saying anything. In fact, what is worse is just last week, I think this week, actually, we won another one. The Mabunda one that went to Constitutional Court on the panel of attorneys failed this month. The Constitutional Court ruled in our favor. Of course, it won't be mentioned. The media is quiet about it. Of course, it does not suit the narrative. So those are the things that we deal with. We reiterate this. We're a law-abiding organization. We'll continue on this trajectory to fight for the rights of our people. We fight for the little girl. Uncle Lawyer has been enriching himself at the cost of the poor girl. We are clear about that. And we said it, I think we said it was in 2020. We said, Uncle Lawyer is peeved. The poor girl is crying. All we are doing is making sure that the downtrodden in our communities can access these services without needing the services of a lawyer. If they do that, it must be by choice. They must not be forced into a plan by an act that says if you come here with your son, I am not going to prosecute this claim. No one can represent you except a lawyer in this case. It's wrong, and I think it's important that we deal with this matter as it is. I promise you, Roy, that I'm going to respond to the joint memorandum by the legal profession on the 20th of August last month. We realize that it's not worth responding. We are not going to respond to them because nothing in what they say is based on any fact. It's innuendos, it's feelings, it's all those things. There's no objective test on which they are saying what they are saying. So there's no need to fit this rumor mill that people have and what they were saying in there. We are prepared to engage them in platforms that we have always engaged them in without necessarily having to go out and respond to them seriatim on their memoranda. So they can come and ask questions about, maybe they must ask the AG what process was followed and all that. The AG will then tell them how they arrived at the conclusion that RAF is doing well. The audit outcome has improved, market improvement from the previous financial year.
Thank you. And we appreciate the comments and the questions that are coming through from the social digital media platforms. I will just read one comment which also entails a question. This is coming from Sumaya Talib. She says, well done for detailing the new target timeframes for processing claims to settlement. What are the new targets to payment of health services to victims in terms of the RAF undertaking? So that is the first one that came through. And then the second one is coming through from Mariette Mini. She says, why are there still payments on the RNYP for over 2,000 days? Yes, 2,000 days. 2 years ago already, you indicated that the oldest claims will be paid first. So those two comments that have questions relates to one question on the RNYP and the issue of undertaking. I will afford the opportunity to our CEO to respond to that before we go to the next rounds of questions on the floor. Thank you.
Yeah, I don't know whether those people are, I'm going to answer to journalists. Are they journalists? Because I hear a certain name there of a certain intermediary who we actually told to go to court. So I'm not going to answer that. They are not even on our RNYP, by the way. If people think that that's the case. They are not on our RNYP. The SLA that we had with the erstwhile attorneys was such that we had to give pre-authorization for certain work to be done. Pre-authorization was not sought. This has also gone to the public protector. Tell her to go back to the public protector. It's very important. This has also gone to the public protector. We have dealt with that matter. They say we owe them, we say we are not liable for that because it did not follow the processes. It's very interesting that when it comes to us, we must just pay without thinking. Others can, if you go to anyone who has got a pre-authorization regime and you do things without pre-authorization, you don't get paid. But at RAF, it must just be done. So this, we have issued statements since 2020. We have issued statements since 2020, 2023. We must answer the same thing again and all that. We are not interested. If they think they have got a case, I think they know where to go. They've gone to the public protector. They've reported us everywhere. It's not in a, we are saying that if you think that we are liable and we say we are not, you know where is the best place to resolve dispute, because that's a disputed case, by the way. So it's not something I'm willing to go into much. It's safe to say it's a known fact. It's about doctors that did not get pre-authorization before they did assessments, which was in line with the survey. So we have repeatedly responded to that. The new target is on payments. I mean, look, we are sitting at 180 days on average. On our less than 180, that's what we target. Usually towards the end of the financial year, you'll see it dropping to an average of 120 days when we do flush the cash and we've got enough cash to see us through. And that we must understand. But let's understand this thing fundamentally about this RMYP that people will not understand. There is a asset liability profile mismatch. It's a lot of English. What am I saying? So you receive your money every month, right, as RAF. Then Collins Lizolo gets injured claims from the RAF. RAF must pay Collins in a lump sum. And there's a lot of Collins, whoever there, as a lump sum. Now remember, you receive your money. So that mismatch creates a liquidity squeeze. So you don't have an asset liability profile matching at that level, which is why we insist on paying in annuity, because we also receive our money in annuity. That will simply say, then we know how much is due the next month, we then pay for it like that. You don't just wake up with some 10 million that someone wants now, when he's going to use it in 25 years to come. So that asset liability mismatch is what is creating the issue around targeting payments and then extending the time frame it takes. Once we start to pay in it, by the way, this payment in installment is not a new phenomenon. Section 17.4 of the RAF Act. Because you see, people will say, no, it's a new thing and all that. It's not. It's not. And I think it's important that we read this section. Section 4A, 17, I think 17.4, is it, ma'am? Yeah, 17.4B. It says, liability for the funds and agent, and the fund on agent shall, where claims for compensation under subsection 1 includes a claim for future loss or income or support. The amount payable by the fund or the agent shall be paid by way of lump sum or installments as agreed upon. This installment payment was here. What happens? When we say to the lawyer, no, we'll pay in installments, they say no. Then there's no agreement. They simply say no, there's no agreement. Because for them, the interest is to get the lump sum now, they get their 25% now. So it's nothing new. It's here. We just are removing by agreement. And we are removing lump sum, and we are removing by agreement. We are just saying annuity. So these things, and as I say, they are simple. They are not difficult things that we are navigating. But the reality is that we want Hlami to be able to say, your payment has started in 120 days. We want to have started paying your annuity in 120 days. That's our target. And we want to say, once we agree, we start the payment almost immediately after the 120 days when we have actually looked at your claim. We hope that in future it will be in much quicker time. Because if you are a child, for instance, the next month, if the breadwinner is not there, the money is not there. The money is not there. So for us, it's important that we do that. And the next month, the money is not there. If they've got to pay school fees are not paid the next month. So for us, it's important that we do it as quickly as possible.
Thank you. Andre Harrison also had a financial related one here. He's asking, why does RAF take so long to settle claims? What are they not telling us? Seems more like a financial issue. So he's asking if we're having a financial issue and why is it taking us to pay claims?
Is he a journalist?
Yes.
Okay. So there is no financial issue. I've already referred to the asset liability mismatch. You have got a liquidity squeeze. A liquidity squeeze simply means you receive your money, your short-term debt or liability is higher than your short-term assets that are liquid, which So liquidity squeeze means you don't have cash. Yeah? We expect money to come in, but we don't have cash as we speak now. Right. So what do? You delay the payment so that you pay the oldest debt first. When we arrived here, we had a situation where people are owed 2,000 days, and the bigger law firms were owed some 30 days. And then we said, no, this does not make sense. How do you owe someone 2,000 days and another one 30 days? We then agreed to 180 days, which is why the section, the Rule 45A, has been asked for from the courts. And they've been granting us that, because they say, pay the oldest debt first, and then gradually do that. If we tomorrow pay in installments, or what we call annuity, that goes away. So there's no issue about the RAF debt. There's no, someone must say they owed me, they never paid me, and they went under. There's no such a thing. In fact, we are sitting in a better liquidity position than we have ever been, ever. So we have stratified our book. You can see the reduction in the short-term debt, because we are saying it was 17 billion when we arrived. It's now sitting at 9.3 billion. We have been reducing it. And how are you reducing it? We take away the money from the legal costs, we pay claimant. We reduce that short-term debt. So we have been aggressively dealing with it. We say if we did not do anything about it, it would be sitting at 51 billion this year. That's what we are saying. So we do not understand, and we don't understand why the insistence that there must be a financial problem. It would have been said by the AG. It would be said by AG. The reality is this: our assets still outstrip our liabilities still outstrip our assets for obvious reasons. But I mean, for us, that nothing turns on that, because at the time when in 180 days your payment is due, we are able to fulfill that. So there's no question about it. So there is no financial issue that we have. And we'll release the annual report, and people can read for themselves, and then they can do the analysis themselves.
Thank you. So ladies and gentlemen, our session is scheduled for 2 hours. We are almost 5 minutes away to the time where we need to be wrapping up. I'm going to afford us yet the last round of questions that we will be taking, if there's any on the floor. And yeah, we will wrap the session up. Thank you. It doesn't look like there are any further questions. So on that note, ladies and gentlemen, I appreciate you taking time to come have a conversation with us as a Road Accident Fund. We appreciate those who have joined us virtually, and we appreciate the questions that have come through. So if there are any journalists that who will like to have further engagements in the form of a brief interview with our CEO, I will advise that you have a conversation with Bonisa. Bonisa, can you please just raise your hand so that they can identify you? We'll make arrangements for that. Other than that, thank you very much. And we look forward to more sessions like this as an organization that is transforming and introducing new things. Soon you will be hearing and getting an invite for one of our exciting innovations that we'll be launching, and we'll be doing a media launch on that. Thank you very much.